All right, are we ready?
Yes, Your Honor.
Okay, on Rashaun Jones, the defendant is present, and I'll allow all the attorneys to put their information on the record.
Good morning, Cristina Diamond, Cristina Miranda on the state. Good morning, for the defense, Alvarez, Cristina Miranda, Jones, Body.
Okay, so today we had limited the hearings to some of Detective Segovia's motions, so I wanted to make sure everybody's on the same page. Yep, all right.
And also the ESPN motion.
Right. All right, so let's just go ahead and knock that out of the way. The ESPN motion to intervene is granted. As I said, that one wasn't going to take very long. I think I saw Miss Levine on the Zoom at some point. Okay. All right. Anyone waiting for Brianna Stringfield? Anyone know who that is? Is that one of our defendants? I didn't see her on our calendar today.
Very familiar. I don't want to.
Okay, I will send her a message to contact her attorney.
Yes.
Okay.
Want to put our number?
Hang on 1 second. Over Miss Spring. Okay, 305
545 160.
All right.
And they'll help navigate this with my attorney. I don't remember their office.
I don't remember her on today.
I
already gave my calendar away, so.
She was someone today. The girl, I don't remember who she was with. So.
Okay. All right. So that we're on the same page, what I have is defendant's motion to redepose Detective Segovia and an order for requiring production of all relevant material. Is that? And then I have a defense motion in limine regarding cross-examination of Detective Segovia on internal affairs complaints. And do you have any other one?
Motion to compel. And the application for a subpoena to Medellin.
Okay. Meta. The motion to compel is which?
Motion to compel disclosure of rating material.
Oh, okay, but that's not limited to Segovia, or it is?
That specific one should be limited to Segovia and something that's real clear.
Can you find me that one? I know there's a few, I pulled out the ones that I had a copy of, but most of them are in the court file.
Filed on May 5th, 2026, at 11:33 a.m.
Okay, while he's looking for that. I received,
Mr. Maroney, what date of it?
Sorry?
What date?
It was May 5th, 2026 at 11:33:41 a.m. I guess there was a lot of.
okay. I don't have them printed.
Is it a motion to compel disclosure of rating?
Yes.
Okay, that one I didn't have. All right, thank you, so I can put it in our file. Any other ones?
We have the motion to eliminate. I believe there was a supplement to the motion in limine. Motion to compel, motion for application of the subpoenas for Meta and motion to redepose. That should be it.
Okay, so that's all, that's the ones I have, or those are the ones that I have. Okay, just to make sure. All right. Okay. I think it's important to start off with something that we had already discussed. Most of these motions start from the premise that the rule of sequestration may have been violated. I think I was sort of clear the last time, but I wanted to expand on it since we had gotten more motions. I had indicated that from my understanding and from what had happened historically, the rule of sequestration was invoked. We instructed the state to have all of its witnesses be aware that they're not to discuss their testimony with anyone else, and that was the extent of it. The rule of sequestration, which was read and explained to the jurors on a number of occasions, was that they were not to, and it was repeated almost daily, not to watch any news media, any social media, or anything like that having to do with this case. Assuming for purposes of argument, because we haven't established any of this yet, that the social media handle that is the one that you're looking at that you all believe is Detective Segovia, regardless of whether it is or it isn't, because we haven't had that hearing, I think it's important to reiterate the fact that I had said that I don't believe that there's a violation of the rule of sequestration even in what has occurred. And I'm going to tell you why. First, I didn't instruct Detective Segovia that he was not to comment on anything online. I didn't think it was necessary. I didn't think it would happen. I figured that they have policies for that. But in any case, he would have been instructed by the state not to discuss his testimony with anyone else. The comments that were made allegedly on social media were in response to, and I'm sort of paraphrasing, an outlet that said opening arguments started today. The comment on the social media was guilty. Well, we all assume that if the detective didn't believe the defendant to be guilty of the offense, he wouldn't have arrested him. He's already established through his testimony a number of times that he believed there was probable cause for the arrest, and has expanded on that quite extensively. So I don't think that that in and of itself is really anything that would violate the rule of sequestration. The next comment was in response to some social media outlet that said the defendant's ex-girlfriend testified that she called incessantly, I think was the adjective, I don't really remember. And he said, that's a lie or that's not true. I think he testified to that. It's not a comment that would violate the rule of sequestration because the lead detective in every case has the right to sit in and hear the testimony of all witnesses. Normally, or in many cases, they sit alongside the state and go through the information with the prosecution. So in this case, Detective Segovia had already heard the testimony of the ex-girlfriend of this defendant. He had already questioned her directly. He had read all of the documentation. Her statement was consistent with the statement that she had given him. He had originally and already testified that he didn't believe her comments about how she was reaching out and didn't know where the defendant was. And that statement is consistent with that and was later consistent with his testimony. In addition, there is no evidence that any of the jurors in that case ever saw any of these comments or influenced by any of these comments. So assuming that I'm wrong and it was a violation of the rule of sequestration, the fact that it didn't influence any of the jurors sitting on the case is extremely significant. That case is over. It's been resolved. It was a hung jury. Those jurors have gone home. The comments are far and past. I think we can address that issue in jury selection, and we will, with the new potential jurors, asking them if they have followed any social media or any media outlets or any stories that have been recorded in this case. Obviously, if they have, we're going to ask them to what extent and what influence that might have, if they can set those things aside, and all of the standard questions that we have in our proposed questionnaires for the new jurors. So I think that that has been alleviated. But so that it's clear, my ruling still stands that I don't believe the rule of sequestration was violated. Even if it was, there's no harm now. That jury has finished its deliberation process. From my understanding, and I guess maybe state can fill me in, from what I understood from some of our last conversations, there was a notice to internal affairs by the fact that the defense filed this motion. And so there was an opening of an investigation or an inquiry or something of some sort where the police department is looking into all of the things that we were looking into here. I don't know if it's still an open investigation, if it is an investigation. I don't know if the state can sort of enlighten us on any of the status.
My understanding is that there's still some sort of inquiry that is open and no final decisions have been made.
Okay,
Or
and
it hasn't been closed. I'm not sure if there's even a decision for them to make.
when you say an inquiry, is it an like an IA investigation or?
They have an obligation when something's brought to their attention just to look into it. So I cannot say exactly
Okay.
what MDSO would say. But when I inquired if it was still, something was still being looked into, they said yes.
Okay,
I
so,
inquired in advance of this hearing, so that way I know it bears on some of the motions. Specifically the defense compelling or seeking to redepose Detective Segovia. So at this time, there's still some sort of open inquiry or investigation.
all right. So we don't know if that's to the level, or do we know if that's to the level of an IA investigation or just an inquiry to see if they open an IA investigation, or you don't know?
I don't know. I believe initially I was told it's just an inquiry because they have to look at everything.
Okay, all right. So understanding that we're going with this premise, I guess the first one that I have is a defendant's motion to compel disclosure of Brady and Giglio material in the constructive possession of the state. State, do you have any Brady or Giglio information at this time to provide to the defense?
I was under the belief that we had gone through this one as well as the one as to the other witness. The state does not. Everything that the defense has provided was publicly available on a public Instagram account. And it appears to be everything else would not be discoverable and it would not be Brady or Giglio. Whether or not a witness has an account or makes comments does not have any bearing on their testimony in the case. Nothing that the defense brought to light, nothing the defense showed us through these screenshots and Instagram posting is something that would have been discoverable and that the state would have had any obligation. There's nothing, there's no inconsistent statements that would become Brady material here. There's nothing that has a bearing on this witness's testimony if it is in fact the detective's Instagram.
So I did grant a motion to preserve, hold on. And I have a copy of it here somewhere. All of the information and what here it is. And what I commented was, I believe that all of it had been preserved and had been complied with insofar as that the defense provided me with copies of what was on the Instagram. Am I missing anything that was on the Instagram that the defense wants me to know about?
So Doug, we're seeking information that goes beyond just those public Instagram posts. We're seeking some information about the registration data, login information, things that are available only to the person who has access to the log into that account. We're seeking any additional screenshots that may have not been posted publicly, direct messages, anything like that that could have some bearing on the case.
Direct, just so that I can understand the scope of what you're asking me to provide.
It's gonna be-
Direct messages from Detective Segovia or from that Instagram, and to whom?
So we're, and to be clear, we're assuming that for purposes of this hearing, that Instagram account does in fact belong to the detective still.
Right, I said I had not made that determination yet. We still have a hearing that we were looking at setting up, but assuming for these motions, in order for them to even be relevant, to even have to hear them, I am going with the assumption that they are his, just so that we can figure out what we need to focus on in these. Go ahead.
It would
Okay.
be any direct messages that relate to the case or discuss the case. So obviously without access to that account, without the information we obtained from Meta, because we haven't been able to send a subpoena yet, without the things we're compelling, we're not sure whether there are any direct messages with a specific person that reference this case. But to the extent that there are, that's something that we'd be entitled to. So sort of to step back, right, to discuss generally this Brady obligation. Brady information applies to impeachment information as well. I think that's something that's agreed to by everybody in this courtroom. But impeachment isn't just limited to prior inconsistent statements. Impeachment can go to a witness's bias. information that shows a witness is biased one way or the other. And I know your honors mentioned that obviously he thinks that Mr. Jones is guilty, otherwise why would he have arrested him? But it goes beyond that, right? It goes to the affirmative step that the detective took in creating an Instagram account that is an anonymous Instagram account that he then used to post publicly about his opinion on Mr. Jones's case and his opinion about the credibility of witnesses in Mr. Jones's case.
So let me stop you there only because I know you're going to keep going and I want to address each point. I did not see in any of the information provided by the defense through their investigator that this account was created at the time, right before or during the trial to address this trial in and of itself. What I saw was that this Instagram has existed for quite a long time. And part of what I was to take under advisement is that there are pictures and comments that include Detective Segovia and rewards to different people from the police department and comments about good job to the police department. So it had been in existence. I don't know exactly how long, months or years.
So
Do we
the
know?
information that we got was that this Instagram account was created sometime in June of 2025, which is important because that's just before this case was set for trial the first time. It was then continued to October and then it was continued to February, but that I believe July was the first time that this case had a trial date and this Instagram account was created in June. So it's right before that first trial. And then it is used during the trial to comment on witness testimony, provide public comment and opinion to assuming it's Detective Segovia's opinion on Mr. Jones's guilt or innocence.
Okay, but it existed for about almost a year before the trial, right?
It would be, I mean, 8 months, 6, 7, 8 months, somewhere in there.
Okay, it's different, 6, 7, 8. Let's do the math. You said June, the trial was,
It's February, so June, July, August, September.
so 8 months.
And
Okay, it existed 8 months before the trial. So I can't assume that it was created solely to comment on the trial, especially that the first few comments had nothing to do with the trial. All right,
And Your Honor, I think the purpose of its creation is sort of irrelevant. I think the fact that he would then use an anonymous account, regardless of why the anonymous account was created, to post on this case, to make public comments on witness testimony in this case, and create a public narrative surrounding this case using his opinion is something that is uniquely prejudicial or uniquely shows his bias, right? It's not something, and even Your Honor said this is something you would assume would not happen. You didn't feel that there was a need to direct any of the state's witnesses about making public comment because you assumed that it was something that just wouldn't be done. I think everybody had sort of made that same assumption, and that's something that's beyond the scope of ordinary detective work and shows that he has an interest in this case that's unusual.
so let me clarify two things. I was asking when it was created because you made a statement to the effect of that it was created for the purpose of. And so I just wanted to address that because I didn't have a clear understanding of when it actually was created. What I remembered was seeing in the statement that there were other things commented way before the trial.
It was created just before that first trial date.
Okay. Well, there is the freedom of speech, and I can't instruct people not to comment about their opinion, just like if the prosecution or the defense wanted to comment to the media about what happened in the case, they're free to do so at their own peril of violating certain rules of professionalism or Florida bar rules or things of that nature. I know, for example, the state attorney's office and the public defender's office have strict rules that they instruct their attorneys not to comment about the cases while the cases are taking place. I can't assume or know what all departments instruct or rules are. And that would be something sort of more internal, which is why I assume they're doing an inquiry. Now, even knowing that those rules exist, if a prosecutor or a defense attorney comments publicly, the only real way that I can address it is by issuing a gag order to all parties. If I had issued a gag order prior, we wouldn't be in this situation because we would have instructed everyone involved with the case that they're not to make any comments socially, publicly, or to anyone about the facts of the case until the case is over, which is why I suggested or brought to light that perhaps in an effort to insulate the second trial, we might consider something of that nature. And we're not talking about it today. But the point is, both sides are permitted by the court rules to talk to whomever they want. It might be prejudicial to the defendant. It might be prejudicial to family members. It might incite violence. You know, there's all sorts of consequences to it. And it would be appropriate if we decide to go forward to take all of those things under advisement and consideration. Oh, it's on.
It's flashing.
It's on. Eric, our clock is still, it's just the connection, but it's on. Thank you for pointing it out, though. It's been happening all day. So I understand that portion. I just wanted to put on the record and elaborate that he has the right under the First Amendment to comment about the facts of the case or to comment about what happened, as long as he is not being unduly influenced or biased by hearing the testimony of another or discussing that testimony, which is why in this particular case, because he's the lead detective and he had already heard all of the testimony, there wasn't anything that seemed to me that changed in either of their testimony that could show some sort of bias because of the comments that we saw on there. I think we may have been in a different circumstance if it had been a lay witness who doesn't have access to the files and the depositions and the statements and the interviews of different witnesses. That would be completely different. So, okay, go ahead with your,
And you're.
I'm sorry, go ahead. Yes,
I'm sorry.
yes, go ahead.
So, I mean, here at issue, they're asking for login records, metadata, private communication. So if the defense keeps saying this is this anonymous account, frankly, being an anonymous account has much less sway. So if you're trying to put an influence on someone, it would have much more influence if a lead detective with all the evidence is using their own name to say like why they believe this person's guilty, what the evidence is. Having this be an anonymous account actually takes away from the influence on anyone else. And I don't think this court has found that there is any influence, nor has any evidence been brought to light by anyone that there is anything. This is an invasion of whoever this account may be's privacy to go into all of this. We can only get this data if there's a warrant signed by a court for a criminal investigation, and there is no crime here. And I think that will be intertwined with later motions too.
Okay, go ahead. Go ahead.
If this information is Detective Segovia's information and is in his custody, as we're assuming for purposes of this hearing, then there would be no warrant required, because then it's presumed under Kyles versus Whitley, as we cited in our motion, to be in care, custody, and control of the state.
Oh.
So that it would be law enforcement, it would be Detective Segovia's information that he has access to. Now, to your Honor's comments about how there are public comments, people have a right to make public comments. Absolutely. But now, having made those comments, if he's going to be called as a witness again in this case, his credibility is directly at issue. It's much different than a situation where an attorney is making comments about a case, because the attorney's credibility isn't on issue in the same way that a witness's credibility is on issue in a case. And there's wide latitude for defense to cross-examine witnesses on their potential motive and bias in a case. And the jury is entitled to hear information about a witness's bias and motive in the case. And taking the time to comment on witness testimony to make the opinion known about innocence or guilt through an anonymous account, knowing that doing so through an official account would link it directly to the police department, and as Ms. Diamond said, be more prejudicial to the jurors potentially, that shows his bias. It's not an issue of whether it prejudiced the jury or not. It's not an issue of whether they saw those posts or not. It's an issue to Detective Segovia's own personal bias that he has in this case. Bias and motive that leads him to testify potentially untruthfully, motive and bias that should affect the jury's weighing of his credibility and his assessment of the case. And I think the fact that he's not a lay witness makes his bias more important, because the state has presented Detective Segovia, and I don't use this term literally, but they presented him as sort of an expert in this case. He came in after 20 years, he's fresh eyes on the case, he analyzed everything, he testified over our objection multiple times, and maybe this won't be an issue at the second trial, but I'm going off this previous testimony. Testified multiple times that Rashaun Jones was a liar, that Rashaun Jones provided false information. He testified that there were no other leads in this case. There was no other person who had any motive to cause any harm to Bryan Pata. And we went sidebar multiple times during that testimony, arguing that he had opened the door to some of the prior incidents that Your Honor had excluded, because that's misleading. And being able to testify about that and testify essentially as to his opinion on everything in the case makes his credibility uniquely at issue, and having a bias in that he takes it upon himself to make public comments and comment on witness testimony while a trial is unfolding, goes directly to his bias and shows he has an interest in this case and an outcome in this case, and he takes it personally, and he takes the investigation personally. And it's something that he has an interest in the outcome. That's something the jury should be entitled to hear. It goes beyond sort of the general opinion that a detective in a case may have as to the defendant's guilt by affirmatively taking those steps to post publicly about it and make these comments.
Okay,
That's something that the jury should.
I need you to explain to me, what the bias is, instead of just saying it's bias. So from what I heard in his testimony and read in his depositions and everything else that was provided in the first trial, he was referring to a fresh set of eyes and looking at the information differently. So we know that what his opinion is. I think he was very clear, like you've said. He said that he thought the defendant was lying. He thought that he was being untruthful, that he wasn't saying where he was actually at. He didn't believe that the ex-girlfriend was calling incessantly, because once he looked at the phone records, it didn't bear out to be accurate, and all of these pieces of information. How does a comment on social media saying, I think she's lying and or guilty, change his position or his feeling as to what he thinks the outcome of the case should be?
Because it shows that he has a personal interest in this case, that this has gone beyond ordinary detective work, where a detective testifies in court, maybe makes some statements alongside the state attorney whenever the state attorney is addressing this case in the media. But he's taken it a step further by commenting through this anonymous Instagram account. It shows that he has a personal interest in it. It's now permeated his personal life and his personal, Instagram account, if the balance of justice, again, assuming for purposes of this hearing, was created by him. It shows that he has a personal interest in it, and he has a personal bias towards Mr. Jones specifically. He's believing that Mr. Jones is guilty, commenting on whether witnesses are telling the truth or not. It sort of has gone beyond what's within the ordinary scope of police work. It's now a personal interest that he has in the case. And taking something into the personal realm is much different than, him testifying in court and saying, yeah, he believes that this witness provided testimony.
So you don't think he personally believes that all of the people that he arrests are guilty, and that he would, I don't understand. I would think I don't see an additional step of making it personal, that it permeates throughout his personal life at home with his children and everything else. I mean, it just seems like he believes and stands up for the work that he's done, and this is why he made this arrest, and he's been very animate about it. The fact that he comments on it, I don't know if a number of officers in other cases have done this. I have no idea. I've never had it brought to my attention. But again, because we have the right to comment and we have the freedom of speech, I don't know that this shows any additional level. People comment about what they had for dinner the night before on social media, and it really doesn't have the weight. Here, he was commenting on, if it's him on that site, about other good jobs that the police department has done, or awards, I think, that people had received and things of that nature. Steve, is there anything you want to say?
Just the defense whole kind of theory has been that Detective Segovia took this personally, that he came in with a bias, that he made the arrest and he wanted personal glory. So this has kind of been the whole defense theory the whole time. And they did cross him on these things at that trial. So this is no different than the cross-examination they already did in the first trial about how he took it personal and he wanted to make the arrest.
Yeah, okay, go ahead.
We have made a theory, and that has been one of the arguments we've made about Detective Segovia's motive and bias in the case. And this, discovered after the trial, furthers that. He has taken it personally. It's now an Instagram account that is an anonymous Instagram account that's making public comments on the case. It's clearly taken here very personally. He has personal interest, personal bias that goes beyond ordinary police work. And the department has a standard procedure for commenting on public cases. You can't, in representing the department, you can't comment on pending cases. Of course, it was an anonymous Instagram account to sidestep that, but it shows that he has a personal interest. He has personal bias. He is taking it upon himself to make public comments on news reporting about this case. He's taking it personally. I mean,
We take
the
this
jury should be entitled to hear that information.
in two parts. The defense says it's an anonymous personal account, but they're saying it's in the state's care, custody, and control in the custody of the police department. You can't have it both ways.
Well, it's an anonymous account in that it does not identify a person. But again, assuming for purposes of this hearing that it belongs to Detective Segovia and the posts were made by Detective Segovia, it would be an account that's in the state's care, custody, and control.
and
Because it's in
they-
the care, custody, and control of the lead detective.
That would be like saying every prosecutor's personal Instagram account is in the care, custody, and control of the state. That every detective's personal social media accounts is in the care, custody, and control of the state.
If
He's not
information,
acting on behalf of the police department making any of these.
if information from a prosecutor's personal account became relevant to a criminal case, I don't think that they would argue that it's not in their care, custody, and control.
I think they probably would, and they would say it's not in their care, custody, and control, but you can subpoena it on your own.
Well, that goes to the other motion that we're.
Right, so, but for, she's saying, you're saying that it's in the state's care, custody, and control. She's saying that she doesn't have access to any of that information. And in order to say that it's Brady or Giglio, you sort of have to know that it exists. So those two statements that we have that we know exist, I don't think they're Brady. I don't think that they're Giglio, as I indicated before, and I don't think that they're a violation of the rule of sequestration, but needless to say, we'll continue with the argument that you think that it shows additional bias. Okay, keep going.
Judge, I think that, I've sort of made the position clear and our writings make the position clear about how this goes to the detective's bias. It just
Okay.
exceeds the scope of ordinary casework and shows a personal bias, personal motive, personal animus that he has for Rashaun Jones specifically. And that's something that we believe should be shown to the jury when they're weighing his testimony.
Okay, state.
I just think that the defense motion stating that all of this is in the care, custody, and control of the state of the Miami-Dade Sheriff's Office is incorrect. This is not Brady. This is not Giglio, as Your Honor has already gone through. This taking it as proffered that it is Detective Segovia's account, saying that a witness is guilty from a witness that throughout the police reports and throughout depositions and throughout prior hearings in court, that this detective has testified to these same things. There's nothing inconsistent, there's nothing different, there's nothing that's not already in the public record, both through public records requests, media articles, snippets of testimony that were played on the nightly news. Also, defense had pointed out earlier that this Instagram account, according to them, was created in June of 2025. After that time, I believe Detective Segovia testified in June at a motion to suppress hearing. I'm not sure if he testified to the ones in the fall, but there were multiple hearings that were in court that were on local media's Instagram account with snippets of testimony, and those were not commented on. So to say they're trying to say that this account was made for this case to comment on things, and then they're trying to say that this is within the scope of like the police department and what the police department controls, but then they're also saying this is an anonymous account. They don't go together. So even taking this as Detective Segovia's account, this could be a private personal account that is not subject to public disclosure, that is not an arm of the police department or of the state. And any of these items in the custody of are not in the custody of the state. There is no authority the court has to see an ongoing criminal investigation to compel Meta to give this data to the defense or the state or anyone. So I just don't think that this is none of this information that the defense is compelling in paragraph like A through E are things that can be ordered or disclosed.
Judge, just if I could briefly respond.
Sure.
So to the extent that it is not in the care, custody, and control of the state for the, reasons that they've stated or the technical reasons about it being an anonymous account, although discussing professional department related investigations. Under Brady, the government has an affirmative obligation to seek out and find Brady information. So to the extent that we're not able to identify specific DMs, specific information related to that account that is not publicly available, that we have not already located and incorporated in our motion, there's an affirmative obligation to review that and see if there is anything in there that is Brady. Second, which also sort of goes into another motion that we filed as it relates to some of the internal affairs information. If any of the materials that we requested in our motion to compel have been produced in the internal affairs investigation and are now part of the internal affairs file for whatever inquiry or investigation that the department's doing into Detective Segovia. Now that is something that is directly within the care, custody, and control of the state, to the extent that their control over these materials is something that matters. So that file also something that was the subject of a separate motion, would now, if it's in the police file, that would certainly be something that the state has access to. If it includes any information that's per your giglio, certainly something that the state would have an obligation to produce.
All right, so,
Well, so Judge, the state also mentioned that there had been hearings after June, which there were no comments from this account on. But specifically, like for the Williams Rule hearing on August 19th, 2015, it does appear that there were some comments on the news coverage after that hearing.
from this website,
From the Balance of Justice account, yes.
okay, what, can you tell me what those were? Because that's not included in any of this thing. I don't think.
It's attached to the motion to preserve those.
Okay,
Different.
can you tell me which statement it was? Because I thought I had read them all.
Attached as exhibit B. The news story on the Williams Rule by. Looks like local 10, the comment was, rest in peace, Bryan, thank you MDPD for a good job.
Okay,
Do you guys have anything you want to add for the record?
Are you addressing the court or me?
I thought you wanted to, you were addressing.
No, no.
no.
no, everyone, let me know. I have no idea. Okay, so there was a rest in peace, Brian. Thank you, MDPD, for a good job, something like that.
Correct, Judge.
Okay,
Yeah. After the Williams Rule hearing, so. To the
Okay.
extent the state was arguing about how there had been no posts related to the hearings between its creation and the trial, there was at the very least that one.
okay. State, anything you want to say?
No, I just wasn't aware that it was from that hearing. We were specifically talking about the ones during trial and it hadn't been addressed earlier in defense counsel's argument, but I take the screenshots as true.
Okay. All right. So anything else? So I'm looking at the defendant's motion to compel disclosure of Brady and Giglio material in the constructive possession of the state. As I have been hearing argument back and forth, I can't find that the state is in possession of his personal. If this is one of them, he might have a few personal accounts. And based on the statements and their effect on a previous trial, I don't find that, from what I've heard, there's anything that would allow me or suggest that I should disclose any of the requests under A through E, Section 3 of the material to be obtained and disclosed for Detective Segovia. And then you're sort of adding orally the information from an IA inquiry or investigation. So,
That's subject to a separate.
Yeah,
motion that's
right.
sort of linked, yeah.
so I'm going to find, for purposes of the motion that I have before me, that's about the Brady and Giglio material in the constructive possession of the state requests for A through E. I'm going to deny that motion, finding that there is nothing that I believe is in the state's constructive possession as to that account, if it is even, because we haven't established that, the detective. So that's denied. And this one is yours because I didn't have it. Excuse me, I'm losing my voice. Okay. I have the defendant's motion to redepose Detective Segovia and for order requiring production of all relevant material at deposition. I want to reserve on that to see if, I think I've said it before, to see what happens with the inquiry or investigation. I think it's going to be very dependent on if it's still open or closed. The trial is set, hold on, September 14th. So I'd like to give this a status date to hear it and see if we have any update. Maybe what I'll do is I'll give it, let's say August 10th. And I would like, if possible, if the state could give us an update then as to what the status is. Is it an inquiry? Is it an open IA investigation? Reason being that I'm going to assume if it's still open, a lot of the questions that you're going to be asking are going to be replied with I plead the fifth, or I can't discuss it because it's an ongoing investigation. He might be advised by his legal counsel at that point not to answer them yet, but maybe he can. Maybe by then it's closed and he can discuss it. So I'd rather hold off and see what they do there, because I think that's going to change the deposition, and I'd rather not do two. So, and I'm setting it with enough time that you have over, a month to prepare and do the depo in time. All right, so hold in abeyance. All right.
I think they touched upon there also their May 5th motion for an application for an order compelling production of stored records from Meta, which was a little bit intertwined with the other prior motion.
Okay, hold on.
And I
Okay,
know-
well, I wanted, what I had prepared next was the defense's motion in limine regarding cross-examination of Detective Juan Segovia's internal affairs complaints. I think that is sort of going to be on the same. If there is, I guess regardless of the status, I think we're going to need to address this once we know what's happened. Being if they close it and there's not an ongoing investigation, or they found that there's no fault or something, I think that's going to change the cross-examination.
Potentially,
And Your Honor, I think you had already previously sort of ruled on this one, and we went into it depending on what the additional material would be, but as
just to
to
clarify,
it,
are we discussing which motion are we discussing?
the cross-examination.
Okay.
Right.
As to his one sustained IA from 26 years ago, I think Your Honor had already ruled that they could not cross on them.
Oh, yes, but that's why I was talking about the one that's
I just
right
wanted
now
to
still
make sure,
potentially open. We don't even know.
since we're going back.
Okay, yeah, so the fact that he had an IA investigation well before this case, or his involvement in this case, I think is irrelevant. So that part we had already discussed.
That was
Um,
previously addressed.
Yeah, so that, and if it wasn't, I'm denying that portion now. Old IA. That one's not relevant. Now, this one may, I don't know. I think we'll have a better idea on the next future date when we hear the status. Okay, so that one I'm going to deny in part, but hold in abeyance to the second part. All right, and then the one that you're referring to about the meta, I know I have it. Here it is. No, this is a motion to dismiss.
I know at one of the hearings where this was brought up, the state mentioned that they had already sent some subpoenas to Meta.
They did. They said that once they received, I don't know if they received it, state, have you gotten
We have
anything?
not, but we don't usually receive this information via, usually it's based upon a warrant, and we have no basis to get a warrant from the court. So it was subpoenaed, sent to Meta at that time, and, here we are 2 months later.
Because I have so many copies of the same ones. Okay. All right, and then can you find me the one, in case you find it before I do the meta? I know I have it, it's just in one of the files. Here, I found it. That's the one I had reserved ruling the defendant's application for order compelling production of stored electronic records from Meta platforms. Yep. I got it. All right, defense, anything you want to add?
No, Your Honor, just to the extent that nothing, Your Honor held that nothing that we requested as it relates to that incident comes in the state's care, custody, and control. This is sort of irrelevant. You know, it doesn't matter whether it's in care, custody, and control of the state. We're seeking to be able to subpoena this information to investigate further, you know, and direct messages, any other information that might bear on Detective Segovia's credibility. And I think the information requested in this subpoena would also confirm or deny whether or not the account is actually leaked to Detective Segovia. So for all the reasons that I previously mentioned about the detective's bias, his personal interest in the case, his personal animosity towards Mr. Jones, we believe that this information would be relevant and seek permission from the court to subpoena those records for Meta, being that the state, or Your Honor has already ruled that it's not in the care, custody, and control of the state.
Okay, so here's part of what concerns me. The request for the production of the electronic records from Meta platforms normally is in response to a warrant, like the state said. There would need to be, for the state to get it quickly. And we sign these weekly. It's very common. You get a potential crime. And part of one of the many things that concern me about the information from the investigator that you all provided is that there's an alleged crime on the document, which would lead me to believe that the investigator was under the opinion or under the belief that there was a crime and that this would be subject to someone's purview. If I remember off the top of my head, it's like a cyber stalking type of a charge that he put there. I don't know. Yeah.
Are you referencing the categorization of this search as threat, harassment, stalking, cyber stalking?
Yes.
So that's something that can be cleared up by the expert who formulated this report. But that's just a category that's assigned to searches. That doesn't necessarily indicate that there is any information in the report that does, you know, is based on some sort of probable cause for a crime. It's just a categorization internally for their record.
Well, here's the reason why, because you can't just get this information randomly without cause. So I think, and we would get that question, you know, an answer from him if and when we do that hearing. In order for him to have a good faith basis to do the search, he has to attribute it to one of the categories maybe that are on his computer. There has to be a reason. If it's a mortgage on a house, or there has to be a reason why it's being investigated and a reason why it would be disclosed, specifically when the target may be exempt from this information being made public. So I don't know.
I can clarify.
Yeah, go ahead.
that as well. So that category is an internal categorization. I believe what the court's referencing is like when someone does a clear search or some other search, they have to put a reason in and certify the reason.
Right.
That's not the type of information that he obtained in this case. Everything in the reports is already public record. It's all already been made public. It's not confidential or some sort of, you know, specific database that you can only have access to for some specific reason. Everything that he pulled, which is then put into that report, is already public. And again, that's just an internal categorization that his company uses to categorize the information.
Well, I would want to know why they would put that category, which happens to be a crime, as the one that they checked off. If it was something that was just public records, I mean, for example, when you go to the doctors, you give the doctor's office your social security number. So it is public, it is given to a third party, but they can't disseminate it and disclose that. They have to protect it unless they are subpoenaed or have a reason to do that. This might be something that was accessible, but there is an exemption and it can't be disclosed. So it's like if, for example, Zillow, I don't know how you say it, disclose the address of the state attorney or the public defender. You know, it would be a violation, even though it's on there. Zillow has the duty to make sure that they don't disclose information that is exempt under the statute. And they get notification of that. And if they violate it, they quickly fix it. And they'll blur it out or they won't disclose it. So here, the problem is I don't have enough probable cause with what I have to sign a search warrant, nor have I received one, but for this information. This information would need to be given as a result of that. So I don't believe that at this time I have the authority to disclose this metadata, but that could change after we have the hearing. But I don't know, we might be able to come to a decision before then, because if the state gets it, I mean, they issued a subpoena, whether they get it or not is a whole other option. They haven't gotten a warrant signed, but maybe these platforms do give it. I don't know. It's not like, it's like phone records. I can't just order phone records unless I have a warrant.
So, Your Honor, so the way Meta, Facebook, Instagram, all of it under the Meta umbrella work, there is a law enforcement portal where you must go in, say it's for a legitimate law enforcement purpose, that you must actually check a box stating this and then upload your subpoena or your warrant or your court order. And if you look on Meta's like website, displays like exactly what is needed. So a valid subpoena issued in connection with an official criminal investigation, and that gets you basic subscriber records. So perhaps the name, when the account was created, then you must, a court order is required for certain other records pertaining to the account, not including contents of communications, which may include message headers and IP addresses in addition to the basic subscriber. A search warrant issued under the procedures described in the federal rules of criminal procedure or equivalent state warrant upon a showing of probable cause is required to compel disclosure of the stored contents of any account, messages, photos, videos, timeline, posts, and location information. That's what they want. It can only be gotten by a search warrant. You know, and there must be probable cause for a crime, and we have not heard any here.
So,
And so on, I'm sorry, Your
Go ahead.
Honor, on the law enforcement portal, Ms. Rodriguez just brought it to me. Under the part where you have to check that I'm an authorized law enforcement agent or government employee investigating an emergency, and this is an official request. Unauthorized requests will be subject to prosecution.
so I don't have any familiarity with the investigating firm that provided this information in the past, as I've said before. Because I'm familiar with these and we do them so frequently, I was concerned and I wanted to make sure that that person, before I let them get on the stand, had discussed with an attorney who specializes in this, whether or not it was in his best interest to divulge it. It was sort of overstepping in my desire to protect a party who may or may not have done something without knowing. The fact, coupled that information that it can't be disclosed and that you have to certify that it is for law enforcement purposes to get some of this information, concerned me because it was coupled with the fact that I read there that there were some crimes alleged. And if he put that information in, alleging that these cyber stalking and the crimes that we just put on the record were the reason, and then signed that he or someone in his firm was an authorized user, it could potentially be a crime.
I
And
don't
he,
think that there was any use of the law enforcement portal or anything like that.
right, so the part that's concerning is because the data that was elicited is personal addresses and phone numbers and locations of two separate law enforcement officers that are privileged under this information, it seems difficult that he would have access potentially to this information, although right now, I don't think there's anything you can't find online.
Yeah.
I really don't. But coupled with the fact that it alleges that there was a crime and this was for a criminal investigation, it truly gave me concern and pause as to whether or not we really wanted to open that door that has nothing to do with Mr. Jones's case. And it has, nothing to do with the trial at this time. It's something that may take on a life of its own. So I'm trying to sort of make rulings without having to go there, so as to not put another person or firm into a difficult situation. Because I think it's really just delaying Mr. Jones's case unnecessarily, because he doesn't have anything to do with it, nor does this case. So it does in the sense that you all want this metadata. So we're sort of going different ways to get the same information because we don't have probable cause for a warrant. It's possible that the defense might be able to gather more information to give us enough information for a warrant. At this time, I haven't heard enough. I haven't heard that there's any crime, so much less probable cause.
And that wouldn't be coming from the defense. They would have to refer it over to another investigating agency. So.
Which maybe they have. That's why I'm saying the defense has to take the
Yes.
appropriate steps, right?
And so what the parameters under Meta's portal are from the Stored Communication Act. It's 18 USC section 2701. So that is something that federal law does not allow private parties to obtain. It's not something the court can enter just from an order. So the state would just be asking you to deny the defendant's application for an order compelling production of stored electronic records, as it is specifically not permitted by federal law. And you cannot turn this over without a warrant into a criminal investigation.
Okay, so I think that's where I was going the last time, and I just put it out there in a bunch of different ways to sort of give the defense an idea of where I was headed. It's why I reserved ruling in case you all found out more information or had another department looking into it or something of that nature. But anything you want to add now? This is not one of those that was supplemented.
No, Judge. No,
Okay.
And on the arguments and the written.
All right, so I'm gonna,
He's also printing on Thursday.
Okay.
In case.
okay, so I'm going to deny the defense's application for order compelling production of stored electronic records from Meta platforms, as I don't have enough probable cause of a crime in order to sign a warrant to order them to provide it. But I will reiterate, if the state receives anything, obviously you have an obligation to provide whatever you receive in reference to the case to the defense. Okay. That's all I have in reference to Detective Segovia for now.
I believe that's all this is good.
Now, we do have a arraignment on Thursday. I don't know if you all are the prosecutors handling it or if someone else is.
It will be assigned to me if it's filed.
It's already
what-
filed, 7/9/126.
What's the case number? And I'll read it.
F 26
Mhm.
123
Okay.
72.
7-0. Let's see. Let me pull up. My computers, you don't know file.
Here, I have it.
You said it was filed 7/9?
I'm gonna file it, read it, but my computer's not.
You said it was already filed?
It was filed on 7/9, but his arraignment set for 7/23.
So I guess if your honor wants,
They-
it just opened. Okay, the state filed a 2-count in case F 26-12372. The state filed a 2-count felony information charging the defendant Rashaun Jones with 1 count of introduction into or possession of a controlled substance in a county detention facility, a felony in the 3rd degree, and 1 count of possession of a controlled substance, a felony in the 3rd degree.
Okay, we already addressed some of this, we were looking, sorry, at bond.
Yes,
So,
there should already be written pleadings in file
Yep.
as well, so.
all right, it's printing, you said on the 23rd.
7/23 for arraignment.
Do you all want to just use today as the arraignment and take it off?
No, it's by room.
Okay, is that
Defense stands
defense?
on written pleading.
All right, so we can take it off and have it arraigned as today.
And you wanna give the same trial date of
Yep.
9/3/9/14?
Yes. All right, so for our purposes, I have other outstanding motions, the gag order and the media. And we also have already July 10th for the motions on the IA.
August 10th?
August 10th.
I'm sorry, August.
There was also the motion on state's motion to compel.
Mhm.
Okay,
I don't believe it's set for hearing.
I think that might be one that we already printed, but let me see. So yeah, I have a number of things, something that we got yesterday at 3:30, the defendant's renewed motion to compel production of George French Jr.'s information, witness communications, and search of certification for a Richardson hearing and for sanctions based on other state selective production. State, do you have a copy of it? I just got it.
Yes, Your
It's-
Honor, I just read it in the break between calendar and these motions.
Most of it is deposition
already-
transcripts?
And most of it was stuff that was already raised in prior motions.
Okay, I haven't had an opportunity to go through it since it was yesterday being a Sunday at 3:30.
Since, Sarah Alvarez and since
Sure.
the exhibit B, references excerpts from George French Jones's deposition transcript, I just want to put on the record and filing it now with the clerk under seal.
Okay. Oh, they already had it here.
Well, exhibit B is not,
Not in here?
no, there's just a cover filed under seal.
I'm sorry, the cover,
There are 3 exhibits.
yes,
Exhibit B is only the cover page.
okay.
It says filed under seal. and
I haven't
this
gone
is
through it, okay.
Exhibit B.
Okay, thank you. So, I will get a copy of that for me, or that one, when I'm ready to go through it.
Okay,
You keep it for now, because we gotta put all this away. That's yours. I have a printed copy. All right, so I received that, and then on Friday, I received something from the state, and that was,
Yes, it was a jail call in support of, basically, in lieu of filing another reply to the defense reply, I thought it was something that was relevant that the state would like to use for argument in reply to the.
all right. Defense, since it was filed Friday, and I got this Sunday, I don't know that you all heard it or had time to incorporate it.
Their motion is
Yeah.
because I filed.
Okay,
So,
okay, so that's what I wanted to know, if you needed time to do that, or I have been, all right, so that, now I understand. We had difficulty opening, I think you said the actual call, we couldn't open the actual call.
a computer generated transcript as well as the
Okay.
actual call, in case your honor wanted to listen to it. It just really, the relevant part in response to the defense was the last page of the transcript. It's a relatively short call, it was 10 minutes, I believe.
Okay, I just didn't know if there was anything else included in the part that I couldn't open. Okay. Can we use the 10th for the media motions?
Your honor, I may be out of town. I was going to have full counsel stand in.
Not gonna be good.
Oh, wait, does that mean you don't want to do the other motions on that day?
I thought the 10th was just set for status of.
On the IA, yeah. Is that okay? Even if you're not here?
Is there gonna be substantive argument, or is it just gonna be an update on status?
Well, I don't know.
If it's on the IA, the court may have a ruling depending on what
Right.
the status was.
We then maybe do sometime the week prior, 6th or 7th, maybe for the media motions and the status.
Hang on one second.
Judge, I think later in the week of the 10th is better because, the week prior is in the conflict and right before that was just to.
Hang on.
That whole week from 10 to.
So we did the
14.
11th maybe instead.
No, he said that whole week, what?
That whole week from 10 to 11 is gonna be tough.
Okay, I have a trial on August 17th and a trial on August 24th these weeks. I'd rather not set it the week before our trial so that you guys have an opportunity. It has to be before sounding anyways. Can you give me a date and I can try to squeeze you in?
What about the the 14th, so that last day of the week of the 10th, Friday, the 14th in the afternoon?
It won't work in my schedule. I can do Thursday. I have a motion to dismiss on Thursday. I can do the afternoon Thursday. It's a pretty big motion to dismiss. So I can do afternoon, or I can do afternoon Wednesday, the 12th.
The clock would be preferable for the state.
The reason that week is gonna be a conflict for me is that I'm gonna be in file, from the 10th to at least the 13th. But I thought maybe Friday in the afternoon would work. Thursday in the afternoon may work, but I think that's.
You all let me know. I mean, I don't think we'll have an answer next week.
I mean, in terms of the state, we can, And
We-
if
we
any
need for-
one of the assistant state attorney, I can convey a message for someone to come to court, or we can send an email.
I mean, I'm trying, as I told you before, I gave this date, we've been in trial every single week. So, so it makes it difficult to go through all of these motions on this case while I have so many other cases. As a matter of fact, today we closed like 15. So I have an Arthur hearing on Wednesday. I have an Arthur hearing on Thursday. I have a trial on Monday. These are all certain already. And a Arthur hearing on the Monday of August 3rd. I can give you what is the first,
I mean, I think we should leave the 10th for the state.
how about the 6th, August 6th?
I won't be here, but I may be able to have your out. One- If it's to report back to the court, yes.
Well, no, it was-
Very short week, because you have arraignments only the third, fourth, and fifth.
But I said the 6th, the 6th I have sounding.
No, yeah, I know, but
Yeah.
I mean, we might have big calendars.
It doesn't matter. It doesn't matter because then we have the 6th and the 7th. Okay, do you want to leave the 10th just then for the report?
We can do 10 for report, and then if we're setting the media motions, we can do
Or-
the afternoon on the 6th after something the report. So.
So we can just have it for report on the 10th in the normal calendar.
Okay, report Rashaun Jones, IA info. And that's at 11, does that work
On the 10th?
on the 10th?
Yeah.
Or, okay,
I can just be in the normal calendar too, just to report back.
okay,
And I'm just asking.
yeah, I can, okay, you said the 11th doesn't work for you? Or the 12th?
Not for substitute work.
What about at 1 o'clock?
Wow.
Oh,
Is it a trial in this county?
Yes. Very good.
that's kind of what happens to me. Then I'm in trial and in trial again.
And 6th and 7th do not work for the court or for the.
6, the state said that the,
2 of the ASAs are out of town.
okay, what about Brittany Cross trial? I have a trial on the week of August 24th. A sentencing on Tuesday. What if I move my trial from August 24th?
That's with me.
It's Brittany Cross?
Yes.
Can we start Brittany Cross on Tuesday after our sentencing? Like at 1? And then do Rashaun Jones on Monday?
Do I?
I was staying around that Monday.
Oh.
I know,
So here's what happens.
I know.
I am doing my very, very best to not move our September 14th. Can we do,
Is there any availability, or you're on, said you're in trial next week?
I'm in trial certain on Robert Turner with ASA Hedrick
Your Honor, now.
and the
that
following week.
Trial cases this morning flat out. How about this week?
For the media motions? Fine.
I mean, the state doesn't really have.
So I have,
Position there, so it wouldn't be.
okay, hang on. I have Arthur hearing on Wednesday,
Mhm.
Arthur hearing on Thursday. So I can do Friday. Does that work? No,
Yeah.
I think, yeah, I think we had already covered this week.
I'll just try to forward, with the standard driving car.
Stand your grounds in Palm Beach County.
Did we say any day next week? Available for anyone? Just throw a day out.
Thursday, no, Wednesday works next
The
week.
29th?
Yeah,
Okay, we found a day. All right, July 29th.
Is this for all of the remaining motions?
Or
Are we
the-
addressing the motion to dismiss today?
Hang on. It's for, well, we could send the motion, we could set the motion to dismiss and the media motion that day, and I'll just block out the whole day. Can you all block out the whole day?
29?
Yeah.
Yeah.
Media motions and motion to dismiss.
We believed that was today as well, not the media motions. We're very clear about that.
You want to do you all have time to do the motion? I mean, I have to give them a lunch break, but do you want to do the motion to dismiss today or no?
Judge, I think we should address that the day that we address, the motion that I filed yesterday, so I prefer to keep it on for the 29th.
Okay. And I'm gonna write then on the 29th also the George French Jones motions. George Jones motions.
So on the 29th, motion to dismiss the George French Jones motion that was filed yesterday, the
Media motion.
gag order motion. And does that, do the media motions also include the state's motion to compel our communications with media?
That was separate today.
Let's see.
I thought it was Segovia motions and those
Exclude-
today. I don't think there's much to say.
What on
And
earth
then
is,
motion to dismiss
Urena
intertwined
Rodriguez?
Segovia and George French.
is Urena Rodriguez a defendant we had on calendar?
I can look that up.
I don't know why I had something for
Let me, how do you spell the first name? I'll search.
Yarina. I don't know what that is. I had that special set for today.
Yeah. It must be that.
Yeah, it's Urissa, yeah. That's, I can't read my own
That's
writing.
not-
And what was that for? Trial? Okay, that's why I had it. I am like, why is this on my special? Okay. All right,
If, in the interest of efficiency, I suppose if the state thought that the motion to compel was set today, I think we can be prepared to address that if your honor wants to give everybody a break and address that this afternoon, and then.
I don't have an issue with that. Yeah, okay, so, can you be back at 1:45? Or you want an hour? Okay, he wants an hour.
What time on the 29th, sir?
Oh, I think it's usually best when I set 11, just so that when I guess, like today we ran over. And other times we have space, so I think it's just safer to tell everyone 11. And then I'm gonna give the staff the hour that they're requesting, because,
So we're not doing 7:20.
Yeah, we are.
The August 10th.
yeah, yes,
Oh, so we do August 10th and 7:20.
yes,
Okay,
different things.
okay.
And then we'll be back at 2. Okay,
They list George Jones by name, George Jones by name. He's not a confidential informant. He's not a confidential source.
He's not a confidential informant, but just as all of these witnesses on this case, a lot of them were listening
Right.
to care of the state to protect them from harassment. He is in a federal detention center. He is now subject to all of the inmates knowing exactly what he said. I think what the court was saying, and not confidential, but he's an informant witness. This is someone, it's like a flip witness on a case where you're co-defendant. It puts them in danger. They have to be, corrections has to take special concerns to keep people separate, to make sure that they're not threatened, to keep them safe. And that is exactly why we did seal this deposition transcript. We just never imagined that an audio file, which honestly is much more prejudicial, could exist and be put out there.
I'm not sure how an audio
But-
file is more prejudicial than the deposition transcript. The deposition transcript is gonna necessarily be filed in the, with the clerk of court anyway. It's the same thing. And the state took no actions before that deposition was taken to protect any of that information. It wasn't designated as confidential. There was no discussion about the confidentiality of his testimony. His testimony was already up there because it was discussed in previous hearings by the state.
Can I turn this over?
Yeah.
I just want to put the rule on the record because council continues to and cited in his motion that there is no rule. The rule is depositions under oral examination, and it's 1.310. We've placed the rules on the record before. When a deposition is taken, and we've again cited to the court reporter, so not to regurgitate what Ms. Diamond has said, but essentially when a deposition is taken, the recording of the deposition is for the sole purposes of the transcript. If a party wants to have a deposition audio or audio recorded or audio or video recorded, they have to put the other party on notice. In this case, they would have had to have put the state on notice, as well as Mr. Jones on notice. The reason that the state took no action before was because just like in every other deposition that we take, hundreds of depositions that happen in this courthouse every day, there was no motion filed by defense in order to have Mr. Jones's testimony recorded, audio or videotape. As we discussed previously also, and I cited to the rules, the civil procedure rules, sometimes in civil cases, there are depositions, for example, of doctors, of particular witnesses where the parties have agreed to, and they agree beforehand, because perhaps they're not gonna call that what you said trial, right? Whether it's a money issue or whatever it may be. In this case, right, that was that has been ultimately the state's issue, and not only was this deposition linked, but it was linked also with his voice, as well as this, right, AI version of the transcript. So the rules are abundantly clear. I think they speak for themselves.
So here's,
Can I be heard, Judge?
yep, I'll give you 1 second. Here's my concern. I know that in civil cases, it's quite common to order from the, the stenographers, the recorded portion. It happens all the time. I've never had it happen in a criminal case, but that doesn't mean that it's a violation of the rule. I think that it's just not common practice, but I don't know that it's a violation of the rule to order it here. I don't know if the admonishment at the beginning, when the court reporter says it's being recorded for court reporting purposes only. I don't know that there is a court ruling on this particular issue as it complies with criminal.
And Judge, the rule that the state is citing to is Rule of Civil Procedure 1.310.
Yep. A4, okay.
It talks about audio visual recordings of depositions having to be noticed. Audio visual means video and audio. It is a recording that includes a video portion, a visual portion, and an audio portion. The plain definition of audio visual means both. That's what the rule applies to. You can see this also when you look later into that statute, where the Florida Supreme Court, who drafts the rules of procedure, specifically distinguishes between audio and audio visual. That's later, or right before or right after in subsection C2, the rule says the party who intends to use an audio or audio visual recording. So as far as notice goes, they only use the term audio visual. And then in subsection C2, they clearly know the difference between an audio recording and an audio visual recording. And then if you look at the previous version of subsection B4, it talks about videotape depositions. So there's nothing in the rule that says you have to previously notice before you take the deposition if it's going to be audio recorded. Every court reporter audio records deposition every single time. At the public defender's office, every deposition that's taken, you get the audio of it. The state's aware of that as well.
No, I don't think you get the audio of it. The court reporter uses an audio in case their transcription is wrong and doesn't, they use it to get their final product. But what I'm going to say is, it's not only for purposes of trial. There is also a wiretap statute that says, so when police officers are taking recorded statements of defendants, even though they're exempt because they're police officers, they inform them that they're being recorded and get, there, now they just put their name. It's only one. Who's the other one?
As far as the wiretap statute goes.
That's it. This one.
Absolutely does not apply in any way to a deposition.
Okay,
The rule specifically requires that you have to have a reasonable expectation that your oral communications are not going to be intercepted by a party. When there's a person there, the court reporter, whose only job it is to keep track of every single word that you say, knowing that those words are going to be used against you in the future, you absolutely do not have a reasonable expectation that your oral communications will not be intercepted in some way. You're there to have your oral communications intercepted. The wiretapping statute only applies to communications where somebody has that expectation. That's not a deposition. It's absolutely not a deposition.
I understand. I'm just saying some of the arguments that we've discussed have been how it's not only the rules, that there's other things that apply. And yeah.
I just want to respond to the audio visual, right?
Mhm.
The reason that the rule describes and discusses audio visual is because when parties agree to depositions being recorded, we agree to it being an audio visual recording. Because an audio isn't going to capture a person's mannerisms. If they, for example, are asked a question about how big would you say the object was, and the person says like this, so that, right, it comes down to very similar to perpetuated testimony. That is why it discusses audio visual recordings. Audio recordings it is abundantly clear in the rule that if a deposition is going to be recorded, and whether it be audio or audio visual, we as the state have to agree. I would also point out that in that same rule, it talks about the court reporter having to transcribed. Audio visual recorded depositions shall also be transcribed unless all parties agree otherwise. The rules are very clear that the parties have to agree.
To audio visual. Nowhere in that rules talks about audio. It's audio visual, video recorded depositions. It doesn't require notice or a recording that is not audio visual. Doesn't require them to transcribe. The rule doesn't apply to any recordings that are not audio visual. Audio visual means video and audio. And the legislature, rather the Florida Supreme Court in drafting this rule, knows the difference because later it distinguishes between audio and audio visual. Audio visual. It never says audio in that rule. Not once does it say audio in that rule. It says audio visual. Doesn't apply at all. Remember, it's just audio recording.
Gotta just pull the criminal rule, which says, let me just pull it, because we did it, and I'll do it again.
But we didn't cite to the criminal.
We did also.
Civil depots, the double rule are under civil.
The one we've been citing to.
The discovery deposition rules are 3.220H. And that outlines the general rule for depositions. It talks about notice, it talks about, and then it says, unless the provision of this rule conflicts with the Florida rules of civil procedure, the procedures for taking depositions, including the scope of the examination, the issuance of a subpoena for deposition by an attorney of record in the action is the same as that provided in the Florida rules of civil procedure and section 48.031 Florida statutes. And that is to protect the deponent and rights of the parties and to ensure compliance with the statutes. The court may enter orders, including but not limited to the orders allowed by the rules, and the rule goes on. The Florida rules of criminal procedure incorporate the Florida rules of civil procedure. It is a rule that we have cited to defense in the past when they have had 5 attorneys asking different questions of the same witness, where we have pointed them to the rule that says depositions need to be conducted as if we were in trial. I think that when we're looking at the rule, the reason that the rule doesn't discuss in the civil procedure rule, again, audio only, is because frequently in civil trials, parties agree because those videos are used at trial. I think that it is clear that whether or not it was going to be audio or visual, the rules, the plain language of the rule is whatever they had wanted to do that revolve, even if it was an audio, they had to have asked the state, and they didn't.
Not what the rule says, Judge. The rule says audio visual.
Okay.
So I don't understand what the state's point is there. If it refers to the civil rule and the civil rule says audio video. I don't understand. You're saying, I thought you were going to read to me a portion that said that the criminal rule specifically excludes or mentions or includes solely
The
audio.
will discuss the same thing, Judge. I just haven't, because I'm up here arguing.
Okay.
I haven't been able to pull it, but I do know that the criminal rules discuss.
I'll give you time to look for it.
Okay, visual recordings and photographs.
Visual.
Again, they talk about the phone. I'm gonna pull the rules, Judge, and then I'll.
Okay,
break it up.
go ahead.
Because-
Go ahead.
because quite frankly, no one, I think, would agree to an audio recording of a deposition without the video portion. But I'm gonna pull it.
Okay,
Well, I
And
think
Judge,
it's
it's fine.
just getting away from
we are.
the.
I don't know how, I don't see how it affects any conduct of this defendant. I think it goes towards my media motion. I think all of these instances that have hindered a clean representation of facts to an unbiased party of jurors, have sort of been hindered in a way based upon all of these little things that have happened. I'm not blaming either group, either party. I'm just saying they've happened. And I don't know who's responsible for them or how they've evolved to this level, but I do see that it is hindering getting a fair and impartial jury in this case. There are so many things that have been either leaked or obtained somehow, or within a moment's notice of a filing that seems very unusual, which is what has prompted me to consider the motions that we're going to argue in the upcoming future, with potential media exclusion and or gag orders. I think all of these as a combination, as a compilation of all of these little things are very significant as to where I got my concerns from and why I'm making this consideration in this case. It's not something that's completely unheard of. There are a number of other states who just recently, on very high profile cases, have excluded the media and issued gag orders until the case is over. And I'm not talking about just one. I think that it's something that perhaps hasn't consistently occurred in Florida, but we haven't had a lot of cases where these issues have come up, like this case. So this may be, a case of first looking for appellate courts. But the reality is, for our purpose here of Mr. George French Jones, I think I would entertain for now, if required, a motion to protect him or keep him separate from other people, from things that have been brought up. I've heard that he may or may not have been attacked or, spoken to or in danger. I don't know that it's directly because of this case, but I had heard that there were some issues. I don't know if this is already in place. Maybe there's already a motion. I mean, something that was granted.
It was granted at the time he gave the initial sworn statement, like shortly thereafter. They were
I don't
kept
remember.
separate.
There was a
Back
keep
in
separate.
2021.
Oh, okay. So,
And then I confirmed that it was still in place when he was transported.
okay, so there was a keep separate. Okay.
There's an active one, and corrections confirms that anytime he comes back, there's a keep separate.
Okay. I don't know if there's anything else that when he's not in our custody that you all need me to help to keep him safe. I'll be happy to take a
I'm
look
not
at
sure
it.
there's anything this court has jurisdiction
Right.
over, since he's in another state in federal custody.
So,
With respect to the motion to compel and.
well, the motion to compel, I don't even think it's denied. I think the state is withdrawing it based on the representation.
Certainly as to the first one, it sounds like that's the second one the defense is saying that doesn't exist either.
Second what?
They're, as to emails with Jeremy McLyment.
What, they already said they don't exist.
Yeah, so there's nothing. The state wouldn't have even filed the motion.
Okay, so it's
Had
been
it
withdrawn.
just been- Yeah.
That's how I interpret it. Okay. Okay, anything else we have to address today, now that those have been withdrawn?
So as to the motion to dismiss, your honor is going to hear that on the 29th.
I had written that down.
Okay, no, I'm just sorry, I'm just to confirm, because, and then that one's intertwined with the motion they just filed, the motion from health production of George Jones, and then you're hearing the media motions that day as well.
If we have time.
Okay, so from what I look at all the motions that have been filed since April 30th. So there's the motions in limine, which we need to get a date, I guess, sounding or shortly before trial. We have the April 30th.
Wait, you're saying April 30th.
Sorry, I'm just gonna go through the motions as I pulled them from the docket.
Okay, hang on, then let me write this down.
That
Go
would
ahead.
help.
Okay,
I'm just trying to make the record clear. I know
Okay.
Your honor has ruled on many of them and reset partial rulings. Okay, so the April 30th motion was defendant's emergency motion to preserve evidence and anti-spoliation. The motion to preserve evidence was granted. Then May 4th, motion to redepose Detective Segovia. On August 10th is stated to provide an update as to whether Detective Segovia is still under an inquiry or investigation by IAA, and you will rule at
Right.
that time. On May 5th, there was a motion to compel disclosure of Brady and Giglio material in the constructive possession of the state as to Detective Segovia. You denied that motion. Also on May 5th, there was a defendant's application for an order compelling production of stored electronic records from Meta. You also denied that, both of those today. On May 6th, there was a defense motion in limine regarding cross-examination of Detective Segovia based on his IA complaints.
I reserved.
As to the prior IA sustained complaint, it was not relevant and denied. And then the open investigation, you'll finish ruling on that motion on August 10th.
Right?
On May 7th, motion to compel complete discovery regarding George French Jones, denied as complied with, and you ordered the state to turn over any prior conviction.
Wait. Okay, hang on. So complete disco on George French Jones. which state says they complied, but defense
You
is saying,
denied most of the motion as complied with. And then you ordered the state at that time to turn over the priors.
okay,
His prior-
do you have his priors?
I ran it, but it's very difficult to determine which counts what charges.
So that's not,
Provide.
yeah, just provide what you have to the defense.
Exactly. I mean, I can paste it into a Word document.
Yeah.
I guess.
That'll work.
That's
And
it.
they'll interpret it. And then before he takes a stand, you all agree or disagree.
Oh, we can do that today. May 7th, motion in limine regarding cross-examination of Detective Segovia. Wait, that was the same one. Sorry, it was filed twice, I guess.
Yes, I had multiple copies, but
Yep,
I don't know if
it was
that's,
On the 6th. and on the
Okay.
7th, per CJIS.
okay.
Okay, so we have pending the May 7th motion to dismiss renewed. And, then we have the June 9th motion to dismiss defense supplement to the renewed motion. So those are they're basically the same motion combined, but the May 7th and June 9th. And then, Your Honor, we just withdrew the state's motion. And then we have,
Wait, states motions
then
to preserve, okay.
then we have the July 1st defendant's opposition to any order prohibiting, I think it was media, sorry, C just cut off.
Yeah, that's what it was.
And then on July 2nd, defendant's response in opposition to entry of any gag order on the defense. And then we have filed yesterday, defendant's renewed motion to compel production. Something about George Jones. Discovery, I guess. I'm not sure what it's entitled.
I'll look at it right now, hold on. Yeah, I have it here. Defendant's renewed motion to compel production of George French Jones information, witness, communications, and search certification for a Richardson hearing and for sanctions based on state selective production. Okay. Now, I haven't read it, as I indicated, because I just got it. Maybe defense, can you sort of give me an idea? Are you talking about the chapter 119 request on what you got, or specific things that were omitted from Ms. Diamond or by Ms. Diamond?
So, no, I'm not referring to the public records request. I'm referring to discovery that's in the state's possession that we have not received, and the jail call that they provided, Your Honor, on Friday sheds light on that, which is one of the reasons why I filed that with the motion.
Okay, I think we can clarify a little bit. It seems that the state provided that jail call because they thought the defense had a copy of an email that was shown to him. Let me ask the state now. State, do you have an email between Mr. French Jones and his attorney, either one of them, specifically without? Okay,
Sent to the state, yes.
And that was.
And
those were
defense
provided.
Public record requests, then they were provided last July as well.
And what are we referring to?
The defense in that motion is essentially asking for all jail calls of George Jones. That we should list anyone who's ever spoken to George Jones or been in a room. And then they bring up a number of a letter.
A letter between,
I don't know who it's between. I know last July, we discussed a letter that the defense was filed, I believe, a motion to compel, and we did a records request across all files, and we let the defense know unless they knew what file this was filed in. We could not locate it, but we looked in all of George Jones files, the files that he had been listed as a witness, which is this case and the other case that we've talked about.
well, maybe Mr. Roney, can you give me more so that I can, in order for me to compel it?
On
I
the
have-
letter?
Yeah, what, do you know the dates or who it's between or anything like that? Because I can't compel a letter in general without,
This last year, it's in the transcripts.
okay, but,
They had no other information at that time,
well,
and we.
maybe now they do because we've had so many supplementals. So Do you know what the letter's about?
Letter, lengthy letter that involved Bryan Jones providing information on multiple.
In a letter?
Written by George French Jones to whom? Okay, so that makes it really difficult for me to compel them to comply if I don't have parameters. It's kind of like,
Letter. I mean, I imagine Your Honor will rule the same way that you ruled last time regarding the letter, which is that if the state has it, they are required to provide it to us.
well, then why are we relitigating it?
Well,
This is why I said these were all intertwined.
If I already ruled on it and I told them before, they have to comply if they ever get this letter or see this letter, if it exists. Why are we putting, see, the issue is I don't want to keep rehashing the same thing, so I want to narrow it down, which is why I asked if you have a date or you have something, I'd be happy to compel it.
it's referenced again because we heard George Jones talking about it in the jail call, and we don't know if the state has additional information that was learned, after we brought this to the court's attention.
Your Honor, this jail call, the letter during his deposition, Ms. Alvarez asked the defendant, asked George Jones about a letter that he wrote to Rashaun Jones. And he starts remembering it during the deposition, and I'm going off memory here right now. And Ms. Alvarez asked him a number of questions, and he basically said it was something sent he provided it to Rashaun Jones before he was sent to state prison. It was basically an apology. I'm not gonna, testify against you. Have a good Christmas. Something about Christmas, something about Coca-Cola. And Ms. Alvarez was asking him questions about the letter. This jail call is not the letter you're referring to, but I believe it's the letter that George Jones is referring to when he's recounting the deposition and what came out in the deposition to a reporter. This call is like his regurgitation of what he was asked.
Okay,
And he was not asked
He was
about.
also asked about that other letter. If the state's understanding is that was, I'm not moving to compel the letter from George Jones to Rashaun Jones.
If the defense has that letter, I would love to have a copy of it. We don't have a copy. It was given to her client and she's asking all these questions about it in a deposition. So I mean, I had to leave the deposition a little early. So it's possible she asked about another letter in the end, but I think it's pretty clear.
I asked about the letter that I had compelled a year ago.
but he doesn't know when or to whom?
Yeah, but when you look at this letter, what he says here is, I kind of remember writing it, but she has that. She has the letter. He's talking about Ms. Alvarez. So she's going to use that letter of me just trying to split up everybody, whatever. And my response was, okay, I didn't mean I was lying. I'm not lying. So the picture she's going to paint of me of a generic stitch. And my response was, it doesn't mean I'm lying. So
Judge,
It was-
speculating. He has no idea what I have that I don't have.
Well,
Like,
he
the
says
she was asked
He's
in the
speculating-
deposition by Ms. Alvarez about a letter.
I got it. He's speculating on how she's going to use it,
Yeah.
but not that it exists, because that's what his understanding was, that it in fact exists.
I wrote that.
Okay, well, I can't grant it if I don't have any more information. So we'll see, maybe between now and then you'll find something. I don't know.
I mean, everything in this motion, which is why I would be fine addressing all of these today, are things
We've
litigated.
related, I know, understand. The only thing I would have to review, if you all want to do them today, and the motion to dismiss, is the added, or defense can sort of tell me if they've added anything in their response that I need to just focus on that, because I've read their initial motion to dismiss.
Are we gonna hear this on the 29th, or we're saying like
No, I'm saying neither. I'm saying I'm willing to hear it if you all want to do it today, since it's only 3:15, and knock it out. It would be helpful if you can point to anything new in this supplemental motion, and we focus on that, because everything else I basically already ruled on. We can do that, or we can do that on the day. I might still be asking the same question. I might ask you to,
So I think we prefer to have it heard on the 29th.
okay. Okay. Anything else?
So we'll do the remainder of the motions on the 29th.
Sure.
Motion to dismiss, motion for gag order, motion to exclude media and the.
Wait, because you're saying them, but I wrote them, I want to check.
I just wanted to confirm that.
Yep.
I have everything. It will be the motion for a gag order
Mhm.
or the briefing, I suppose, on the gag order, the briefing on excluding the media. The motion to dismiss. And linked to that would be the new motion that was filed yesterday related to George French Jr. I think that would be everything.
That's what I have.
Yes.
Anything else?
No.
Okay. All right.